Welcome to The Voice of Retail. I'm your host, Michael LeBlanc. This podcast is brought to you in conjunction with Retail Council of Canada. Meet Daniel Jenson, Major Case Director at Competition Bureau Canada, with the third of 4 episodes created to help us understand the laws governing and protecting retailers. If you want to learn more about the Competition Bureau and how it operates, tune in to the series' first episode back in October. In this episode, Daniel unpacks antitrust and abusive dominance for us, providing us with a specific case study to illustrate both the concept and the tradecraft of the Bureau. Let's listen in now. Daniel, welcome to the Voice of Retail podcast. How are you doing this morning?
I'm doing very well. How are you doing, Michael?
Fantastic. I'm really enjoying and I'm getting great feedback on our series. And for the listeners, this is another in the series from the Competition Bureau Canada, informing and advising and providing resources and insight to retailers and the community. And if you want to learn more about the Competition Bureau itself, I refer you to, and I'll put a link in the show notes, right back to our first episode. So we won't spend much time together, Daniel, talking about the Bureau itself. We'll get right into your area of expertise. But again, for the listeners, if you want some context, perhaps you missed that episode, Nicola does a really nice job of outlining how and what the Bureau is and how they operate broadly. But for you, we're going to dive right into some interesting work in anti-competitive and that kind of area of operation. But let's start with a little bit about you. So who are you and what do you do for a living? And tell us about yourself.
Sure. So hi, everyone. I'm Daniel Jenson, and it's a pleasure to be with you all today. Right now, I'm the Major Case Director and Strategic Policy Advisor in the Monopolistic Practices Directorate of the Competition Bureau, which is really the part of the Bureau that deals with abusive dominance, which is what we're going to be talking about here today. Speaking a bit about myself, I've been with the Bureau since 2013, and I have a background in economics. And really kind of like the core of my job historically and at present is both leading abusive dominance investigations and providing advice with respect to those that are led by others, and also developing Bureau strategic policy. One thing that let me also just take a very quick second to say at the outset, which is everything I say here today represents my own views only, and that any errors or omissions are my own.
So your economics background, tell me a bit more about that. What, there's lots of different elements of economics. Were you always interested in the nature of markets, basically, and what makes them work and what makes them malfunction? Is that something that always interested you, or were you drawn to that in your studies? Talk about that for a little bit. So it's kind of funny. In some ways, I think, when I first went down the path of economics, I did it a bit arbitrarily. What happened was that at a certain point in my undergrad degree, I happened to take a class about competition law, and I found it really interesting. And so I took some more, and then I went off and did my master's degree and, continued to focus in that area. And personally, I just find it to be a really interesting space because I think is something that's really important to our day-to-day lives. And I think that it is important for understanding how the process of competition affects us and how it should be protected. Well, you're right about that. I mean, it is a hot button issue, and it's one that garners a lot of media exposure and a lot of exposure for the Bureau. And it is one of those things. But I suspect it's also one that is slightly either misunderstood or people don't know enough, and that's why we're here talking today. So let's jump right in. So we're focusing on explaining antitrust, abusive dominance from your perspective. Let's start with a very plain language definition for the listeners to ground our audience in what you consider these things and what they mean from your perspective, from the Bureau's perspective.
Yeah, sure. So, I think that at its core, abusive dominance specifically, and in many ways competition law more generally, is about protecting the process of competition from powerful firms doing things to harm it. The idea is really to preserve competitive forces, to keep rivalry intense, to ensure that they are what determine market outcomes, rather than large players put a thumb on the scales. Markets are competitive. The outcomes of that are really valuable. So it gives consumers lower price services, broad varieties of products, and new innovations. It's a process that rewards those companies that outcompete their rivals on the merits. Now, I think it's also important to understand a bit about what abuse of dominance law is not. A common misconception is that it's about breaking up monopolies, and that's not exactly true. Just having a dominant position or even having a monopoly isn't against the law in and of itself, or charging high prices as a result of that. It's really the abuse of that position to affect competition, which is a problem under the Act. So conceptually, abuse of dominance is when a dominant entity uses that position in a way that results in competitors or competition being less effective.
This is a really interesting point, I think, for the listener, and that's understanding at its core the difference between something and someone, an organization being very, very competitive, working hard, building a strong business, building advantages. We all want to build advantages versus the competition to leverage against competition and gain market share or whatever, versus being, anti-competitive. Like, tell us a little bit more about that, because I think it's really, I'm sure in your minds, is that a darker line than a grayer line? Like, chalk the field for us to mix metaphors a little bit about the difference. You've already said, interestingly, a monopoly is not necessarily anti-competitive, but articulate that a little bit more for us so we can understand.
Probably the best way to identify what sorts of things are abuse of dominance is that they're about making it so other competitors are less effective. For example, hobbling your rivals or making them want to compete less, rather than helping the dominant firm compete, or simply doing things that are competition itself. So maybe to give a bit of an example that might help illustrate.
Yeah, that's super helpful.
Just being big and having enough scale that you can sell better products at a lower price than other rivals and still make a profit, that's really just competing, even though it might have the effect of putting competitors out of business because they can't match that.
You said something interesting there, and I want to pursue that just as I think about it. Because I know there's, and it's not in your realm, anti-dumping, where you would have industries or countries even that put in products and don't make a profit and lower the price. So that matters too, to you as well, that maybe they're not making money, they're selling at cost or below cost. And, that sometimes is a legitimate strategy, and at least in the short term, for businesses to kind of gain market share. Talk about that a little bit.
Yeah. So, when it comes to the selling of products below cost, that is something that can be an issue under the Competition Act in some circumstances. There is a line of cases that deals with the idea of predatory pricing. So that's the idea of selling products below cost with the aim of eliminating your rivals and later on increasing prices because you've gotten rid of those rivals who would otherwise prevent you from doing that.
Right.
I think that the lens that we approach this from is a bit different than anti-dumping under trade law. That's not really an area that I would kind of say I'm an expert in.
Sure.
But the idea of selling products below cost is something that can be an issue under the Act. But, I think that it's also important to recognize that and I think that this is also a very important point to emphasize, under abuse of dominance law, there's no behaviors that are inherently anti-competitive. You can't just point to saying, hey, look, this company is selling products below cost, and therefore that's automatically an abuse of dominance. Instead, what we have to do is we have to conduct a detailed analysis of, is this firm dominant? Are they doing this for an anti-competitive purpose? And is this having the effect of substantially lessening or preventing competition? I think that part of the reason why is easily illustrated by predatory pricing, or maybe to put it a bit more accurately, low pricing. Often we want firms to price low,
Sure.
That's a good thing in most cases for consumers. And there might be legitimate reasons for even selling below cost in some cases.
Sure. Maybe you're overstocked, or maybe you've moved manufacturing to a different place and you dramatically affected your cost of goods or something like how do you think about that? Like, there's one thing to say you're selling below cost. There's another thing to saying you're just not making any money. First cost of the good versus the actual selling price kind of good. So do you got to peel that back and try to get into that once it comes to your attention?
Yeah, I mean, when we look at allegations of predatory pricing, I think it's also important to recognize those are only like a small subset of potential abuses of dominance.
Give me a few others.
Yeah, sure.
Yeah,
sure. I'm happy to go there. One, to give some other examples, and probably more common ones. For example, exclusive contracts. That would be where, for example, a dominant firm goes to the companies who supply it and says, hey, you can only sell to me. Or alternatively goes to the people who sell its products and say, hey, you can only sell my products. Mm-hmm. Another example would be tied selling.
Let's unpack that one a little bit, because that's a very relevant one to retailers, right? A vendor comes in, a scenario where says, listen, I've got this thing. And of course, retailers, there's no room on the shelf, right? In any general selling proposition, you've got to remove a product to add a product, right? Generally, notwithstanding, endless aisles and things like that. So if a vendor comes in and says, listen, I want you to sell my product. I want to take over the shelf. I don't want you selling the other product, but, I'm not going to sell it. I'm not going to be the second on the shelf. So either it's mine or my way or the highway. You would view that as sideways?
I mean, it could. I think, as I said, nothing is automatically an abuse of dominance. That's the sort of behavior that has the potential to be an abuse of dominance, certainly. But, to know whether it truly is, we'd have to look at a number of factors, including, as I say, is the company who's doing it dominant? Might there be pro-competitive reasons why they might want to do it? What amount of the market do those practices cover? If it covers a lot of the market, does that make it more difficult for other manufacturers to compete? It's a very detailed analysis, but that would be the sort of thing that, depending on who's doing it, could certainly make our ears perk up.
Interesting. Let me give you a different context and turn the camera around 180 degrees. So I think of, and I was speaking to someone about in the United States, and of course you don't operate in the States, but just for context example, 2 office supply companies said, we want to get together because we think we'll be better being one. And their perspective generally was that there's a lot of people who sell office supplies, right? But the way that case went, or the judgment went, was that was too much concentration. Does that fall into your realm as well, that there's, coming together in similar markets as similar organizations, you examine that? Does that fall within your purview?
Well, it certainly does within the purview of the Bureau on the whole. Mergers and acquisitions are something that are one of the core things that the Bureau reviews. Those typically wouldn't be considered to be abuses of dominance. There's a different legal framework that pertains to that, but there's also other parts of the Act that, depending on how they operationalized that, could apply. For example, if they didn't merge, but they just entered into an agreement to set their prices between them, that could be a concern under the criminal conspiracy provisions.
Right.
A joint venture between them, that falls under a different provision of the Act. So it's certainly something that the Bureau could look at on the whole, though.
Now, once you do this work, and I imagine the investigations take many, many, many months, if not years, what action or remedies do you pursue? What is your area? Do you have civil, criminal? Can you break things up? And talk about that for a bit.
Maybe to take a little bit of a step back and talk about the Bureau's overall process. Generally what happens is that when we become aware of a situation that might be an abuse of dominance, we investigate. And if we look at it, and I think it's right to say that investigations can be quite lengthy. Abuse of dominance investigations in particular can often be incredibly complex and fact-intensive. But if we do that investigation, it seems like there is an issue. There's really two paths forward for us. The first one is that we can negotiate a voluntary resolution with that company who's engaging in the practice. But if that isn't successful, we essentially sue them in front of the competition tribunal, which is you can think of it as a specialized court that hears certain matters under the Competition Act. In terms of what the outcome of that can be, there's a number of different things. Under the abuse of dominance provisions, probably the core thing, the core remedy that tends to be imposed is getting the firm to stop what it was doing, to stop that thing that was the abuse of dominance. It's also possible for the tribunal to order, that firm to do other things that are necessary to kind of overcome the effects of their conduct in the market. That could theoretically include breaking up the firm. However, there's never been a remedy of that nature for.
Yeah, I was going to say I can't recall anything that extreme. It typically is there's stop sells or any other kind of different mechanisms, but it doesn't feel like it's gotten that extreme. Though you could authorize that. Is that something that's theoretically possible, or something you guys could do?
It's something that's theoretically possible, yes. In fact, it's explicitly talked about in the Competition Act. But, again, I think that would be pretty extreme. And I think you'd probably have to think about why it's necessary to go that far versus why it wouldn't be enough to say just stop them from doing that practice.
Right. So I can imagine at dinner parties and cocktail parties, you're a popular fella in terms of, hey, I saw this going on, and that feels anti-competitive to me. What is the most common misperception, asked differently, in our conversation that you would correct and want to correct, both with everyone listening and in general? What did people generally misunderstand, so to speak, about the work you do and those lines that you chalk?
Yeah. I mean, I guess for me, I kind of go back to a point that I mentioned earlier, which is just being dominant or just charging high prices. That isn't an issue under the Competition Act in and of itself. I think that might be a pretty common misconception. I'll admit, before I personally got involved in competition law. I had the vague sense that one of the core things that happened was you couldn't be a monopoly, and if you became a monopoly, well, you get broken up. But that's not exactly right. Really, it goes back to the idea of being dominant and then using that dominant position to affect competition. That's really the core of it, but it all ties back to that harm to the competitive process.
Well, it's a great discussion so far. Let's, if you could, walk us through a recent example, if there's one you can share that kind of takes us from start to resolution. What off mic, you and I talked about a specific one. Share with us an example that helps illustrate some of these concepts, principles, and outcomes.
Yeah, sure. So probably the best example I can talk about is the Bureau's case against the Toronto Real Estate Board. It's one where kind of the procedural history of it is fairly complex, so I won't get into it, but, just to give people a bit of a sense of the timeline, this is a case where we initially brought our case against TREB in 2011, and then the litigation ran until 2018.
Wow.
So I think it's also important to take a second to emphasize that, as I said, investigations can take some time, but then the actual resolution of the case before the competition tribunal, that can also take a while, as this shows. So maybe to give a little bit of background, which, some listeners might already know, TREB is a trade association of real estate agents, primarily in the Greater Toronto area. And TREB does a number of things for its members, but probably the most important thing they do is they operate the multiple listing service, or MLS. The MLS itself does a number of different things, but its primary function is really that it's a place where agents acting on behalf of home sellers list houses for sale. And because of that, it's one of the main places where agents representing buyers go and look for houses. So it performs that very important function of showing what's out there, being a buyer or a seller. However, as a consequence of that, when listings get put into the MLS, there's a lot of information included in that, information about the property, its listing history, previous sale prices, stuff like that. And in and of itself, that plays a very important role as well, because if you're, say, an agent acting on behalf of a seller, it's really helpful to be able to go in and look at what did other houses around here sell for. For example, when asking, what should I list this house for? And, the exact same logic applies when you're acting for a buyer. So the MLS, in addition to just being the place where you find properties or list properties, it also has a lot of really important information in it to help agents provide advice to their customers and clients. And so, as a further consequence of all of this, the MLS is really important to access as an agent. And because to access the MLS, you need to be a member of TREB. And that gives TREB the ability to impose rules about how its member agents compete, and therefore a dominant position. So what did TREB actually do that caused Peer to investigate? So the case against TREB revolved around access to this MLS data and what agents can do with it, which was accepted as harming competition between agents, in particular relating to virtual office websites or VOWs. So if you're unfamiliar with that term, a VOW is a secure, password-protected area on a member's website where you can display listing information, among other things. And why this is important is that, historically, there's a lot of information that real estate agents would provide to their customers and clients, and call it manual ways, right? Like the house down the street sold, we'll give you a call and say, here's what the price is. Or we'll, if you're really old school, fax it or email it or what have you, right? But the nice thing about the VOW is that it allows customers to go and look up that information themselves. And this is a sort of competition that TREB was preventing, in the sense that by imposing certain restrictions on VOWs, which I'll talk about in a second, this prevented new, disruptive, and innovative real estate brokerage models from emerging that used these online services. And, maybe those models would have been a threat to agents who more traditionally operated in kind of a bricks and mortar, face-to-face based manner. In terms of more specifically what TREB did, really there's two parts to it. First, although TREB allowed VOWs to some degree and had implemented a basic data feed with information on active listings, that really didn't include a lot of the information that was really core in the MLS database and important to agents, customers, and clients.
It wasn't enough information to make the market, so to speak. It was just a sample of the information. It wasn't enough, basically, in your eyes, or as you're describing it, right?
Yeah, that's right. So really the information they put out there was just about active listings. So a property currently offered for sale. And that's important. That's very important. But, if
history is very important too, though. History is important too, though, right?
Exactly. And that's what really Treb withheld. It didn't provide information about historical listings. Didn't provide information about sales prices. It didn't provide information about listings that were withdrawn, expired, suspended, or terminated. And that meant that, hey, if you're a customer who's interested in a property, but maybe that property has a history of being unsuccessfully offered for sale, that would tell you something about the nature of it, to see that, it was listed last year, been taken off after a month and listed again, taken off.
Sure. Very important
you couldn't
information.
See that.
Yeah, very important.
So the second thing that Treb did, which is also very important, is that it prevented the use of any information in this data feed to be used for analytics, basically. You couldn't take this data and say use it to build some sort of an automated estimate of, here's areas of the city where there's a lot of activity going on. And so that, despite the fact that it also didn't include a lot of information that would have been helpful for analytics, even the more limited information that was there couldn't be used. And that prevents another form of competition. It prevents agents from developing analytical tools that maybe would help their customers and clients see, what's going on in the market, or developing tools that maybe would just be internal and would help that brokerage compete. Ultimately, we brought the case against Treb before the tribunal. As I said, it ran from 2011 to 2018, but we were ultimately...
now, is that, that timeline, these are obviously very complex. Does the timeline, does it reflect a complexity of the case, or does it reflect a judgment about the case that this may or may not be? Like, I guess by the time that's a lot of resources to use in a case. You don't make these decisions lightly, I'm very, very sure, because your expectation would be, it would take years. So I guess, is that common that, well, listen, this is complex, it's going to take a while to figure out, versus it's just complex and it's going to take us a long time to explain it and go through the process? What was your view on that? Well,
I mean, I think that, this case is probably a bit of an outlier in terms of how long it took. In fairness, part of the reason why was that we initially brought the case in 2011. I think in 2014, the tribunal, they issued an initial judgment where we lost. We successfully appealed that. Then we went back to the tribunal. Treb appealed, and so there were a number of steps there, right? But I think it's also fair to say that, even though that this was an outlier, it still can take time measured in years from the start to end of litigation. So that's probably a bit of an outlier, but
in terms of time, but not in terms of principle. So, three things that in your mind stood out about that. So obviously they had a dominant market position, but you and the Bureau said, well, listen, you're using it to disadvantage and seriously impact competition. Is that a fair summary of 7 years of back and forth? Is that an accurate summary? If we had one or two lines to just summarize why that's a good case to understand.
Yeah. Well, I mean, I think that, maybe to summarize it, I think that it's important because this is really something that does have a very substantial impact for home buyers and sellers in Toronto. Members of Treb can now compete in new ways. Like consumers have access to more information on the internet than they had before. Agents are in a better positioned to develop data-driven services than they were before. And all of that means that home buyers and sellers are better informed. And I think that's important.
Okay. So scope and scale matters. Basically, I mean, housing is obviously both important to us individually and to the economy and to everything, right? That market flows, as you would say as an economist, efficiently, and the market clears well. And any sand in the gears of that market is very, very important for all those reasons, right? That's why it rose to this level of scrutiny and resources. Yeah.
Yeah, I think that's right. And I think it's also kind of helpful to note that, although this was a case about the Toronto Real Estate Board and competition in Toronto, following this, many other major real estate boards have revised their own practices as well. So, I think that, it's probably something that has broader impacts beyond Toronto as well.
Right on. All right. Well, listen, this has been a great discussion. It's obviously of great interest for a whole bunch of reasons to the listeners. Now, let's talk about, in the course of this, listening to us, they, or in their experience, someone listening might have or observe businesses they think the conduct is offside, as we've been talking about it. What can they do? Can they reach out? Is there resources to go learn more beyond this? And can they reach out and ask, hey, is this behavior offside? And could you investigate, or what would it take to investigate? So talk about basically getting in touch, learning more, and getting in touch even to report suspected abusive behavior.
So I think that what I would say is that if anyone thinks that they're aware of anti-competitive behavior, they should contact the Bureau. There's information about how to do that on our website. And, I think we can definitely provide some links to help people with that. Mm-hmm. The other thing I'll just say is that if maybe you're just kind of interested in learning a bit more about abusive dominance, we also do have a number of materials on our website, some of which are at a relatively high level, but also some much more detailed technical information, such as our specialized guidelines on this. I think we can also include some links to those if they're of interest to people.
Right on. All right, so I'll put lots of that in the show notes, lots of ways to get in touch. Well, listen, it's been a great discussion about such a fundamentally important issue, and you've done a fantastic job of kind of laying it out for everyone at a high level, and whether they're experienced or just learning about it. And as I said, I'll put resources and links into the show notes. Daniel, thanks so much for joining me on The Voice of Retail. Another great discussion, helping retailers understand and helping the folks listening understand the Competition Bureau, your what you look at, what you consider on-side and off-side. Fascinating discussion. Listen, I wish you the best rest of your day. And once again, thanks for joining me on the podcast.
All right. Well, thanks so much, Michael. It's been a pleasure to be here and to chat.
Thanks for tuning into this special episode of The Voice of Retail. If you haven't already, be sure and click and subscribe on your favorite podcast platform so new episodes will land automatically twice a week. And check out my other retail industry media properties, the Remarkable Retail Podcast, Conversations with Commerce Next podcast, and the Food Professor podcast with Dr. Sylvain Charlebois. Last but not least, if you're into barbecue, check out my all-new YouTube barbecue show, Last Request Barbecue, with new episodes each and every week. I'm your host, Michael LeBlanc, president of M.E. LeBlanc Company and Maven Media. And if you're looking for more content or want to chat, follow me on LinkedIn or visit my website at meleblanc.co. Have a safe week, everyone.